my name is Grusic. I'm a lecturer at UCL Laws and I'm the convener of the LLM International Arbitration module. I would like to say a few words about the module to help our students make their selection for next year. So the International Arbitration module is actually split into two parts. The first part of the module, which comprises approximately 2/3 of the material, concerns international commercial arbitration, whereas the second part of the module, which concerns the remaining 1/3, concerns international investment arbitration. So international commercial arbitration. This part of the module starts with an exploration of the legal framework of international commercial arbitration. And here we will cover different laws and rules that govern international commercial arbitration and the way in which these different laws and rules interact. Following this, we will have a series of lectures dealing with different aspects of scope, validity, interpretation, and the effect of arbitration agreements. And in particular, we will discuss different strategies on enforcing an arbitration agreement and different strategies on resisting the enforcement of an arbitration agreement. Following this, we will have several lectures concerning procedural issues that arise in international commercial arbitration, such as interim measures and other powers of arbitrators. We'll also talk about some duties of arbitrators, rights of arbitrators, the principle of confidentiality, and so on. Following this, we will cover the meaning of an arbitral award and also different ways to challenge an arbitral award and also different ways to recognize and enforce an arbitral award. So these are the topics that we'll cover in the first part of the module, which concerns international commercial arbitration. The second part of the module, as I mentioned, concerns international investment arbitration. Now, I should say that international investment arbitration comes in two forms. On one hand, we have international investment arbitration that takes place under the auspices of the International Center for the Settlement of Investment Disputes. And then there are also international investment arbitration, which do not take place under the auspices of the ICSID Center. In the second part of the international arbitration module, we will deal with both ICSID and non-ICSID investment arbitration. The bulk of this part of the module will concern the jurisdiction of investment arbitral tribunals. So we will explore different ways in which the parties can agree to arbitrate an investment dispute. We will cover the meaning of investor, the meaning of investment, the meaning of the state in this context. Following that, we will cover several issues concerning arbitral procedure, but issues that are peculiar to investment arbitration, such as transparency, interim measures in this context, and so on. And finally, we will conclude the module by discussing different ways of annulling or setting aside an arbitral award and recognizing and enforcing an international investment arbitral award. Now, I should say that we also have several guest lecturers who will appear in the module. Lord Collins has already confirmed his attendance in one of the lectures, and we will also invite some practitioners to, if nothing else, tell us a little bit about their practice. And finally, who is this module aimed at? I should say that this module is suitable for anyone who has academic interest in commercial arbitration or investment arbitration. But I would say that the module is particularly interesting for those students who want to enter legal practice and become part of dispute resolution departments in major law firms. But the content of the course should also be useful for those students who want to work as in-house lawyers in major firms that are engaged in commercial and investment arbitrations. And finally, it should also be useful for those students who want to represent and advise the governments who want to defend investment arbitral proceedings.